Good afternoon from the West Coast. Good evening to wherever you are, or good morning if you're in Hawaii. I wish I was there. It'd be really nice to be in Hawaii right now. To be quite honest, I was just listening to the earnings call of Tesla. I think of interesting note. This has nothing to do with the purpose of this live stream, but of interesting note, they indicated that unsupervised FSD would be across the country. I think by the end of the year. So pretty interesting. Starting in Austin in about 6 months, apparently. So what I wanted to talk about, but that's not why I wanted to talk about, and I also didn't want to talk about MicroStrategy, but I briefly will. MicroStrategy is a company that raises capital to buy Bitcoin. And I know I made a post somewhere that they don't use all the money for buying Bitcoin, and the person objected to that. And I saw that they have I think they're going to do a $2 billion raise using preferred stock. And in the filing, it says it's for balance sheet purposes and for buying Bitcoin. So it's not unreasonable for them to use it for balance sheet purposes or for administrative purposes, but you have to recognize that, and that's going to be factored in, that if they're doing capital raises, that there may be some actual dilution and not accretion. They claim it's accretion because they're buying Bitcoin, and then the amount of, and I know it sounds like nonsense, but there is a theory here, and the amount of Bitcoin per share would increase as they basically borrowed to buy. That's kind of the story. So I did that. But just to be clear, that they do use part, at least in the $2 billion raise that's coming up, they're using it for other purposes other than just pure Bitcoin. Before I rant about GTII, which I'm going to, and thank you for all being here. This is obviously not legal advice, of course. It's not any advice. I hope you like the snow in the background. The weather really is changing out here. It was windy and now it's snowy. So what can you believe? But before I start and give you the update about GTII and what you all want to hear, I started out with nothing and I still have most of it. And last and not least, or least and last, my first job was working in an orange juice factory, but I got canned. I just couldn't concentrate. Okay, let me breathe for a second. So I try to keep you informed, as I promised to do. I promised, and I think I've kept my promise, about at least supervising this entire thing to kind of keep you informed about what is going on. I am a plaintiff with a bunch of other people in an action. We're represented by counsel. There's a receiver involved. The receiver has counsel and has corporate counsel. So the receiver has two sets of counsel, one that represents them in the litigation, same litigation that we are all in, and one's a corporate counsel that would do like corporate stuff and security stuff, like a merger agreement or issuing preferred stock. So today happened to be, and so I have communication, or at least I try communication, although since I'm involved in a case where, even though I'm an attorney, I'm represented by an attorney, really they shouldn't talk to me, but whatever. I still assert questions and ask questions just so it's out there, and I always copy our counsel on it too. So recently there's been a bunch of interactions, and I have a lot of interactions. I don't like to report all the interactions because, one, it's boring, and two, it may not be helpful or misinterpreted or anything like that, and nothing significant has, nothing other than what I've disclosed has happened. But there was, some interaction. There was a recent filing about, because there was going to be a status conference today. Now we're talking about GTII. So they're in the case that's pending in Las Vegas. There was going to be a status hearing today to follow up about the status of that potential transaction involving that AI Vertiz. I forgot the name of the company, but the company that they issued an 8K, and they were considering doing a merger where that LLC, which is that AI company, would come in and would merge into GTII. And in return for that, they would get certain rights. And the way the agreement is written or can be construed, and this hasn't been determined yet, and I'm not, by the way, so I'm not accusing anybody of anything. I'm just stating the way I see it. So take it for what it's worth. They submitted some documents, and in the documents, it provided somebody who would be involved in a merger like this, they would get a certain amount of preferred shares of stock. So there's different shares, different classes of stock in GTII now. There used to be only, I don't know if there was only one, but there were mostly common Class A for us people. And there may have been some other preferred that were authorized but not issued. I don't know if there are any issued, but now I know there's 1,000 apparently that were issued. So that's another class of stock. And the rights of this class are different than the rights of us Class A shareholders. And in this, and so there's two separate documents. There's this document that sets up these Class B shares, and that was done by the company. And then after that, there was a merger agreement that was prepared, at least tentatively, because it requires some exhibits that aren't attached, and that's not uncommon. But the merger agreement refers to that same stock issuance. So they kind of work together. And in the stock issuance, it says as to these preferred stock that they get certain enhanced voting rights. So, and it's hard to tell from the way it's drafted, which is one of my concerns, by the way. And again, it doesn't have to be intentional, just could be not, it may just be ambiguous to me. I'll be gentle in the language. But there was some ambiguity, I thought, in both the stock grant and in the merger agreement. Now, the merger agreement more was just the absence of information, and that can be filled in. But the stock issuance, that I think that was already done, and I think it needs to be clarified or corrected or whatever. But there were three issues in the stock issuance that relate to the merger and why I'm even talking about this. And there were three issues: were the voting rights, dividend, and a priority in terms of disbursements upon dissolution. So and there's a bunch of other terms, but those are the three that stood out to me, just kind of on quick look. So the first one, the voting rights, it appears to have given this new company who's being merged into GTII, and whoever in that company would get the preferred stock, it gave them substantial voting control over the company. That's what it appears to state. Now, it may have been just poorly drafted, or it may be what it says. But at this point in time, it's impossible to tell. Hey there, JR, by the way. It's impossible to tell. And I asked for clarity about that. And the concern is, it may be perfectly legit. This still may be the best deal. I don't know, because I haven't evaluated the deal yet to this point in time. But we all have to be aware that if this goes through, that us shareholders would lose a lot of voting power. Now, perhaps the acquirer or the acquired would be benevolent dictators, and they would operate in our best interest. I don't know. But, being around the block a few times, and as you guys have been around the block a few times, I'm somewhat skeptical, even if it turns out to be true. So the first item that I wanted dealt with, and has not yet been dealt with, but I'm sure it will be, because there'll be a point that you'll have an opportunity to participate in this also, is the voting rights. Second issue was dividends, and I don't really care about that. It was basically that the preferred would get 2 times the dividend of the common. Okay, so if you're putting up a bunch of capital, and I should go back to 1. So this all determines about what you're bringing to the table. What kind of capital, what kind of technology, what kind of future revenue and income, because you could bring in revenue, but you could still lose money. And I really don't see that as a great virtue. If you're bringing in prospective profit and value, that might be different. But at this point in time, As far as I know, I still don't know what kind of capital they're bringing into the deal, and I'm not specifically knowledgeable as to technology or future technology. I know they have no revenue, or at least that's what it was asserted, that they had no revenue as of now, and they would be producing, or they used to hope to produce revenue by the second quarter of 2025. But I don't know in what amount. I don't know how long it's going to take them to be profitable. I don't know what the value of any of this is, even though they do in the documents. And again, I haven't gotten to the main point. In the documents that's submitted, there's a valuation, and again, I didn't look. I looked at it really quickly, but the valuation was something of this particular LLC that was bringing this technology into GTII. The valuation, the market cap, I guess, that's brought in, I think was like $330 million. But I don't know the validity of that. And what was interesting to me, because I saw it yesterday, that was the first time that it was produced, about 3:45 Pacific time, the day before the status conference, which also caused me a little concern, just to be up front with you. But I looked at it. It's a valuation. It kind of used the basis of the valuation using other AI entities like XAI, et cetera. And the timing was impeccable because DeepMind's model came out, and all these subsidiary, basically modeling companies' valuation may have been crushed, but they used some of that to determine the valuation. Now, no revenue. I could value the company at $1 trillion. It could be whatever, but it could also be worth 49 cents. And so, without more detail, I can't approve of that. Now, I haven't got to the third point, but I just wanted to address this really quickly. Now, I think the company has indicated a willingness to provide more detail. Now, the company is not GTI, I mean the acquired company. And I think it's led by Mr. Forrester, I believe. They've agreed to provide additional information. And I offered today to do a live stream on a Sunday to let the shareholders, get an idea. I wouldn't be trying to lead them anywhere. I'd say, here, make your pitch. This is up to the court, and it'll make sense to you why I made that offer when we get to the end of this. And to this point in time, I have not heard yes or no. Now, there may be some concern if it's my client and they're involved in some transaction that might be in a court. Do I want them to appear on a live stream? Perhaps not. But if you certainly want to clarify what you bring to the table, it certainly is a device by which you could do that. And I'm sure JR would come on and help me ask questions. He'd be certainly a more neutral party, or less neutral, or he'd still be thinking about his Philadelphia Eagles and if they're going to win the Super Bowl or not, which I don't think they are, but that's just me. So we have the two. So far I've gone through the two issues. One was the voting rights, caused me concern. Two is the dividend. 2x, I don't really care, but it was unclear to me if it was limited just to the 1,000 preferred shares or some multiple of that. So I just needed some clarity on that. The third issue was some priority rights upon dissolution, that if in fact the company broke apart and monies had to be distributed, the character and the scale and how it was divided up, that was, I thought, unfair, or it seemed to be excessive. The way it was drafted, and again, this is part of my concern about just the documents and the clarity of the document. The way it was drafted, it seemed like that everyone with a share of that preferred stock would have a $4 million distribution priority, which would, if there was some kind of dissolution and there was money to be distributed, even if there was significant monies, under that scenario, I really, if I can, I'll do it. I'm going to invite, let's see if I could do it. Oh, I can't do it. I'm sorry. I was gonna do something, but I'm sorry, I can't do it. I tried, because what I'll do is I'll knock myself off. JR just invited himself on, and I would be happy to have him, but I don't want to like blow you guys off. But I'm happy to do another one with him later this weekend where we can talk about the next stage of this. So I'm sure he would love to do it while he's considering his Eagles. So we got the two issues. I'm trying to get this done as quickly as I can in my head. So we had two issues. We had the voting rights, then we had the dividend, and then the third issue was the priority. It seemed like that was excessive, especially if you're contributing $4 million, perhaps, or $40 million, but I don't know what you're contributing. So why should you get a priority of X number if it doesn't relate to the amount you're bringing to the table? And at this point in time, I don't know. So I was concerned about that. So yesterday there was a brief filed late in the afternoon. And even though I was told previously that the hearing today was only to just to kind of be a status hearing, I read the brief that was filed literally 3:45 p.m. yesterday afternoon. So I looked at it probably around 4:30. No, 5 o'clock, 5 p.m. Pacific time. I spoke to our attorneys probably around 6 to 6:45 last night. And it was filed by the Receivers Council. And I have no connection to that council other than I've communicated with them at some point in time. And then it suggested that they were seeking the approval of the court. Made me uncomfortable. So I made sure to attend the hearing today, which I did. And at the hearing today, they did ask the court to approve the transaction. There were a bunch of who was there at the hearing today. The hearing today was Reichman's counsel, I think 2 Reichman's counsel, I think Kathy Griffin's counsel for the receiver, counsel for us. That's multiple counsels. So it's probably like 7 or 8 attorneys, I think. And most of the hearing was conducted by the attorney for the Receivers Council. Is a very polished and experienced attorney who's been involved in matters like this. But again, it wasn't supposed to be a hearing for the approval, but I didn't want to take any chances, so I appeared. So they went through it, and eventually the court, because this judge, whether I don't know how this case is going to turn out in the grand scheme of things, but I can't say anything negative about Judge Williams. I think he's a very competent, qualified judge, and he was a prior practitioner. He's in the business courts in Vegas, and he handles complex litigation, and he kind of knows what's going on. So I can't attribute anything negative to him. I think he's doing a great job. So part of what happened today was he raised the issue that because in the one of the papers that was filed recently by the Receivers Council in seeking the approval of the court, they said it was too burdensome to give notice to all the individual shareholders. So I was, let's say I was annoyed by that request. So again, I made that clear to our attorneys. And today I'm there, and the proceedings are going on. The court, by its own, picked up on that and ordered notice. And I'll tell you what the notice will be and what your opportunity is. But I kind of want to describe what went on in the hearing. So the attorney for the receiver went on for a while, and then the other counsel for, I think, Reichman spoke for a little while, and then the attorney asked for anybody else wanted to speak. Now I hadn't appeared, and even though I'm an attorney, I'm not supposed to appear in that court. But I waited like a couple seconds, and I then introduced myself to the court that I was here for the plaintiffs. And about 3 or 4 seconds later, our attorney piped in, and I kept quiet from that point in time. But I introduced myself to the court. And the court, I think, got the point, and that wasn't because of me, but the judge, who's an experienced judge, wants to make sure that all the shareholders have an opportunity to be heard and to object to any transaction. And our counsel supported that, and eventually that was agreed upon. So what's going to happen is on Friday, Friday will be the 31st. An 8K will be filed. It may also be reflected on Twitter. I don't know, but I know an 8K will be filed, and I'm sure somebody on GTII will post the 8K, and the 8K will reference a hearing on this particular acquisition that's going to be set for February 19th at 9:30 a.m. in the Las Vegas court. Now, even though it's in Las Vegas, and even, I'm sure a bunch of you may want to go, but you all can appear by Zoom. So in that same filing, and if we don't get it, let me know and we can work it out. But in that same filing, there should be a Zoom link, and that should permit you to appear at the hearing on the 19th. Now, you can appear and watch, although we don't want to like overload the system so it can't function. But you're certainly welcome to appear and watch, and you're certainly welcome. I mean, I'm not gonna tell you what you can and cannot do. Although, as a group, we want to put our best foot forward. But anyone can object. They can appear on Zoom. They can, as long as they're a shareholder, they can say, "I'm Joe James, and I either approve or don't approve of this transaction." And you could say why or what or which way, or you can ask a question. If there's something about the transaction that that is you don't understand, or you can ask the court. And what will happen is, since there will be a bunch of attorneys in the courtroom, you could ask the question, and the judge will present the question to the appropriate counsel. And there's a bunch of shareholders here, so one, everybody is welcome to participate. And I urge everybody with an interest to participate and to let other shareholders know that also. And so that's one aspect. And again, if you have nothing to say, that's fine also. But if you have some serious question, I mean, ask it, because we're not going to be able to think up. I have my own, I kind of went through briefly some of the issues that kind of stuck out to me just quickly. But you all may have different concerns, and yours may be much more valid than mine. And the judge might feel more interested in hearing them, plus or minus, because maybe you think it's a great deal after you hear, after you get all the information. So there'll be an 8K filed. It should have a link, and it should also provide a link or a some type of citation to provide more information on the company that is being acquired. So the just to be clear, the CEO of that company was upfront and welcomed the opportunity to kind of talk about the company. He didn't in the hearing, because it just didn't occur, because again, it ended up being, despite the request that it be a hearing to to approve the deal, it didn't end up being that. It just ended up being a hearing to set up the hearing about the deal. But again, if you have anything to say or any questions, feel free. You can submit your written objection to the court. And I think you all have the case number. If you don't, let me know, and I'll post it on Twitter, and you can all circulate it. But you all can file it with whatever you want. It'd be an object. I'm not going to tell you what to file, because I don't represent you. But the court was saying that would hear all objections. Didn't have to be necessarily a written objection. You can make an oral objection at the time of the hearing. The court is in trial that particular day, or at least it thought it was going to be in trial, but it set aside at least a couple hours for this. So don't be bashful, but also let's try to be productive. So let's make sure they're, as opposed to being, because I have a lot of these, as opposed to being like pissed off questions, let's try to make constructive questions. And that includes, I'll put this out again, that includes anybody has a prospective transaction with GTII, who has either contacted them already or not. Join the party. If you have a deal and you think it's better than the deal that's being presented, then I invite you, even though I don't have the right to invite you, of course. But listen, what's the better time than when the court is considering the transaction than having a transaction to contrast with it? And again, a couple of people have reached out and contacted me, so I think they've contacted the receiver or will. And again, anybody who's interested in participating, please come out. So we'll get the information on the 31st. After I have an opportunity to kind of review it, I will do another live, and maybe JR will help me on that one, kind of analyzing the information, at least. And again, you can make your own conclusions, because maybe you think it's a great deal. And by the way, I should start it on about on that. And I'll get back to where we are at 131. Part of the pitch also was to get the and this is very important. I should have kind of talked about this earlier. Part of the pitch also was that the audit had to get this trading again. The audit has to be completed, and there has to be some ongoing business to make sure it doesn't get delisted. So, notwithstanding the terms of the transaction, the receiver, and I think the judge believed this too, that you needed both elements. Now, what the terms and what type of business is, that's the $64,000 question. And I think whoever that business would be would need to infuse capital quickly into GTII so it could use it for legal and other purposes, because it was certainly referenced that legal expenses and litigation is expensive. But those two elements they believe were necessary. Now, the audit, I think, is going to be completed very shortly. I mean, very shortly being, I hope it's this month. And the business, obviously, they're in a hurry to get that done now also. So to give the receiver the benefit of the doubt, he believes that both those elements have to be completed to get it trading again. And I'm not going to dispute that. My only, my objection to this point in time is the quality of the information and documents that I've seen so far, and some of the terms that I think are too onerous for us shareholders, because I'm in the same boat as you. So those are the two issues. So to kind of give the receiver the benefit of the doubt on that, and because the court agreed, it seems like completed the audit, which I agree with, and getting some business going would be important to get it uplisted to at least pink sheets. And I think that's the goal, as asserted by the receiver today or yesterday, is to make sure it got uplisted to pink sheets where everybody can trade it. And that's where it was before. And even though it's not the highest standard, at least then we're not boxed out and not involved. And again, I'm not making any recommendations in terms of the quality of this transaction. I just don't know enough information about it. And based upon what I see to date, I couldn't approve of the transaction. The court that has ultimately is going to make the decision might think differently, but I'm just telling you where I am at. So I've blabbered on. So 1/31/2025, they'll do an 8K, and also will file a motion to have that particular transaction approved by the court. That motion will be heard on February 19th. That's the hearing that you all be able to appear by Zoom. And any opposition to that motion, which our counsel, if they agree with me, will be filing, has to be filed by February 12th. So I would suggest that any written objection that any of you have to file should be filed no later than February 12th, and if possible, before that. And listen, the more input from shareholders, the better. Whether it be positive or negative, I want this to be, really a reflection of how all the shareholders feel about these transactions. And again, the receiver would have no interest or no positive interest if the company gets shut down. So I believe the receiver is working in the best interest of keeping the company going. I just may have a dispute or a disagreement about the terms and about protecting shareholders' our particular rights. So that's where the difference is. But I don't want you to misinterpret me being critical of the receiver in terms of what he's doing, because actively, and I've been in cases in California involving receivers, actively he's been busy. I just have certain things I'd like him additionally to do, and that's where we are right now. So opposition has to be filed February 12th, and your objection, I'm suggesting, should be filed no later than that date. There'll be some reply filed on February 17th and a hearing on the 19th. Will the judge rule on the deal at that point in time? Don't know, but he certainly can. But in other proceedings that we've had before this court, the judge usually took it under submission. That means he kind of didn't rule on the moment and ruled at some time thereafter. And again, I have my own reservations about the deal. Well, the total number of shares, will they remain the same? It will remain the same as exists now, but that number has already changed because there was 1,000 preferred shares that have been issued, if that makes sense. And the 1,000 shares by itself doesn't make a difference because that's not going to significantly impact it. It's the voting power of those 1,000 shares. So will our number of shares remain the same? Yes and no, because that 1,000 shares really has a lot of power. And so from a realistic purpose, no, your shares won't have the same value. And, as long as everybody is on the up and up and management's good, then, things will work out. But your control certainly gets minimized. And again, the other aspect was the distribution and dissolution. And if money is distributed, that's where those shares come into play also. And that may never happen. It may be an unreasonable concern, but it could happen. And we still don't know how much money they're bringing to the table. And again, what are their future plans, and why do they think they're going to be profitable? And again, there may be great answers to this stuff. It may be the case that this is NVIDIA that we're talking about, and we're just early stages. I don't know, but I don't know. I don't know enough at this point in time. So just to kind of answer, if Paul will not respond, then reach out to him. If he or his counsel don't respond, then you can come to the hearing, appear at the hearing, and reflect. You tried to reach out to the receiver and he wouldn't respond, and file an objection to the motion. Yeah. So those are both. Now, I'm certainly recommending to. I'm probably going to be present. I would certainly be at the hearing, whether I'm on Zoom or in the courtroom. I'm probably going to go in person and be there in person. But you have the opportunity to object. So if you don't like if it's significant, because the judge is not going to want to, let's be realistic. The judge is not going to want to hear a bunch of bitching, because after a while, the judge is not going to be interested. What the judge wants is concrete issues and concerns. So the judge knows, because he indicated today, the judge knows we've all been screwed. The judge knows that. So the judge is looking for the best alternative under the facts for the company and the shareholders. If we have concerns, because he's not going to have read every single thing, it's up to us in part to raise those concerns for him so he sees those issues. And that's why I kind of sorted out those first three issues that will be, I guarantee you, one way or the other, they're going to be before the court, and the judge will make a decision about that. So again, I urge you all to reach out and express your opinion, participate, object or agree, whatever you agree. Again, it's not my call here. It's whatever the shareholders call. But however you feel or whatever your concerns are, express them. And let's try to do it again, because we want the judge to be helpful and consider our concerns. So to the extent we can do it in a professional and non-threatening and accusatory manner, let's do it that way. And I can accuse everybody on this channel to give us some relief. So I will keep you apprised. And again, everybody who's around who sees the 8K, just post it online. And the 8K probably will also have the case number. It will. The 8K will also have the case number and should have the reference to the objection. So all the information, the contact information necessary to file the objection should be in the 8K that's going to come out on the 31st. If it's a problem, let us know. Let JR know. Call him up on the phone. Let us know, and we can kind of like help with the details. Anything else that not really. So that's about it. That was a significant hearing. It was kind of annoying. I was really annoyed last night, to be honest. I am a great sleeper. Last night I was really annoyed, and I could not sleep I was thinking about that because it was annoying. And whatever my annoyance was, it turned out to be correct. So, but be that as it may, it doesn't really help us from this point in time. So everybody, look out for the GTI 8K on 31st. We will do another live stream kind of after it comes out. Review it yourself. Review the deal. And if you have questions about the deal that we're not answering, when JR and I hopefully do another live stream, we can answer some of those questions. Or, again, if you're not involved in a lawsuit, because I should have made that also clear. To participate in the hearing on the 19th, you don't have to be involved in the lawsuit. All you have to be is a GTI shareholder. So the hearing is open to anybody, whether you're a plaintiff or not. So again, I welcome anybody to do it in a professional way and constructive. And if you're there and you are listening in, and you're going to ask a question that's been asked and answered already, again, we're trying to make it as efficient for the judge as possible, because the judges have they have tight, especially this judge, very tight calendars, and they will appreciate brevity. If you get right to the point, whatever your concerns are, that's great. But it applies to every shareholder. So you don't have to be a member of the plaintiff's class. Any shareholder can assert their objection. And again, the judge was really welcoming about that and thought it was really important, and as I did also. So that's it for the time being. I will look out for it on the 31st. You all look out for it too, the filing. And after it comes, we'll talk about it again. Think about, because there's already a filing that has the terms of the deal. It was done on January 13th. There's a filing, and attached to the filing is the agreement. And there's also a filing with the stock issuance. So if you go to Edgar, the Edgar system, if you Google Edgar and you pull up GTII, it'll pull up all the filings. If you go to the GTII investor relations site, there also should be a tab for filings. And you can review and it would be the most recent filings. So for you guys, it would be the January 13th and the 15th filings, the filings in January. Look at all those, and there'll be some attachments. The attachment will be a copy of the stock issuance and a copy of the merger agreement. It's attached to one of those documents. Look at both, and if you have specific questions about those documents after you had a chance to review them, then we can talk about them, or I can try to to clarify it. It's not, listen, I wish it was easier. It's just not. And, we can bitch about it. I'm just trying to inform you of what is going on and in the case. And the judge, again, seems like a reasonable judge, and he's diligent. And we will see when the next step comes. And again, I invite everybody to participate, state your opinion, object, agree, ask questions, so you feel satisfied you've done whatever you can do. That's the idea. So we will talk later. Be well, take care, have a great afternoon, and talk to you later.